A contractor agreement does two different jobs at the same time, and the standard commercial template only addresses one of them. The agreement signed at the start of a working relationship sets the commercial terms: money, scope, ownership, exit. In the coach-on-coach context, where the contractor is another coach delivering under your brand or with your clients, the agreement also carries professional obligations from the ICF Code of Ethics. The template downloaded from a legal site rarely names those obligations. The work in this unit is to keep both jobs in view from the start, so the ethics layer is documented rather than added by reaction the first time a difficult situation arises. Two jobs, two registers, and both have to be present in the same document. The first register is commercial, enforceable in court, reviewable by a lawyer, money on the line. The second register is professional, accountable under the ICF Code of Ethics, with ICF Core Competency 1 and Core Competency 3 both having standing in the arrangement. CC1 demonstrates ethical practice, and CC3 establishes and maintains agreements, are the anchors. The standard commercial template addresses the first register cleanly and is silent on the second. The coach-on-coach version puts both in the same document. The commercial layer is 6 elements, and the order matters less than the discipline of naming each one explicitly. Scope of services: specific enough to enforce, flexible enough not to slide into behavioral control territory from Unit 12.1. Deliverables and payment: what is produced, when, at what rate, through what invoicing process. Intellectual property: work for hire for delivery work, explicit carve-out for the contractor's pre-existing frameworks and tools. Confidentiality: mutual surviving termination, covering both business information and client information. Term and renewal: project-based or rolling with notice, never indefinite open-ended. Termination: notice period, right to cure for performance issues, immediate for material breach. There is a trap inside the scope element that connects directly back to the classification test from Unit 12.1. Compare two scope clauses for the same associate coach engagement. Clause A, coach 5 clients per month through the program curriculum, is specific enough to enforce and leaves the contractor in control of the how. Clause B, coach clients. Tuesdays and Thursdays at 2 p.m. using the structured reflection method is specific in a way that crosses into behavioral control. The second version dictates schedule and methodology, which are exactly the factors the IRS test reads as employee indicators. Scope language can quietly classify your contractor as an employee without anyone noticing until the audit. CC1 demonstrates ethical practice, has standing in the agreement because ICF Code Standard 2.6 puts you on the hook for your support personnel's code adherence. The code language reads directly, I am responsible for my support personnel's adherence to the relevant standards of the Code of Ethics. The contractor coach you hire is your support personnel in the structural sense, and their conduct in sessions with your clients reflects back to your professional obligations. CC1 in the agreement is not a paperwork upgrade. It is the structural acknowledgement that Standard 2.6 requires documented, not aspirational. Translating that into agreement language produces a specific clause, not boilerplate ethics language pasted at the end of the contract. The professional standards representation confirms that the contractor coach holds the appropriate credential or training for the work, operates under the ICF Code of Ethics or an equivalent professional code, and maintains the code-required confidentiality standards through every engagement under your brand. This is the concrete written expression of Standard 2.6, sitting in the body of the contractor agreement where any reader can find it. Without that clause, Standard 2.6 compliance is aspirational. With it, the compliance is documented. CC3 establishes and maintains agreements, handles the harder structural problem of the coaching agreement transferring through the contractor relationship. Your client signed a coaching agreement with your practice. When you route that client to an associate coach, the agreement obligations transfer through the contractor agreement. The associate has to operate under the same scope, the same confidentiality, the same engagement obligations the client originally signed. The contractor agreement carries the transfer mechanics. Without that explicit transfer language, the associate operates under whatever their default coaching contract was, which produces a misalignment between what the client signed and what the associate delivers under. 3 ICF standards reach into the coach-on-coach context even when they don't generate their own clause, and the contractor agreement has to acknowledge them at the implication level. The 1.1 co-creation requirement now runs through 2 contracts at once, the agreement with your client and the agreement with your associate. So the obligations have to thread between them without contradiction. The 3.1 multiple agreement disclosure carries weight because 3 layers are operating simultaneously: client coach, principal contractor, and brand holder delivery agent. The 3.2 conflict of interest standard catches the predictable case where the associate develops direct rapport and the client asks to continue with them outside your program. That scenario is foreseeable, and the agreement has to name how it gets handled in advance. The attorney engagement at Module 3.4 is what handles the customization layer that matters for high-stakes elements. 5 situations where an attorney's review goes from helpful to required. Significant intellectual property creation, where the contractor builds programs, assessments, or curriculum that sit inside your brand. Substantial client list access, where non-solicitation scope matters. Revenue sharing arrangements rather than flat fees, because royalty mechanics are contract law and not commercial template territory. Operation in California, New York, or other aggressive worker classification states. Contract value high enough that enforcement might actually become real. Below those thresholds, the starter template with the CC clauses covers most situations. Walking 1 or 2 associate model scenarios shows the gap that competency level provisions actually close. The associate hears something significant in a client session and picks up the phone to talk it through with you. Standard 2.6 makes you responsible for confidentiality, and a generic commercial contractor template gives you no framework for the handoff. The client asks the associate to continue privately after the program ends. Standard 3.2 makes you responsible for managing the conflict, and the template carries no client transition mechanics to manage from. The provisions that close both gaps live in CC1 and CC3, and they have to be built into the first draft of the agreement before the first associate signs and the first scenario arrives.